Well, hello, everyone. It's great to see you all today. It's December 1st, 2022. Hard to believe we're getting near the end of the year already. Today, we've got a fantastic program. The topic is the first 5 minutes, maximizing the potential for success in mediation. And I'm sure we will learn a lot. As you know, these programs, Will Work for Food, the New Possibilities Hour, they are the speakers and everyone is donating their time. There is no charge. We merely ask that you make a donation to either the food bank of the speaker's suggestion or to one of your local food banks. And it's just amazing how much has been raised so far. Jeff, you've got the number, I think, today. How much are we so far, and what does it mean?
Thanks, Jean. It's just fantastic. So far, since we began this in the spring of 2020, our generous audiences have contributed a grand total of $334,692.35 to food banks around the world in honor of our great speakers. Every dollar provides many meals for people in need all around the world. So that's millions and millions of meals to combat food insecurity. Thank you all so much. We look forward to continuing long into the future. Jean, back to you.
Thanks, Jeff. It's just amazing, and that's so many meals. So thank you so much, all of you, and let's hear what we've got today. We have two speakers today, Brenda Waugh and Elliot Hicks. Brenda is a lawyer, mediator, and restorative justice facilitator with Waugh Law and Mediation in Virginia and West Virginia. Prior to this position, she served as an assistant prosecuting attorney in Berkeley and Kanawha counties, counsel to the West Virginia Senate Judiciary Committee. She clerked with the West Virginia Supreme Court and was in the legal services attorney. She was a legal services attorney. She's taught law at law schools and contributed to a number of publications. She regularly presents workshops. She's a proud alumni of UVA with her bachelor's, West Virginia University with her doctorate, and a master's degree from Eastern Mennonite University. And so we're so happy to have you here, Brenda, today. Thank you so much. Elliot Hicks, I've known for many years, and it's a pleasure, as always, to listen to Elliot speak. And many of you may know him as also as a participant, a member of this group. He comes to these Will Work for Food programs many weeks. He practiced law, I'll put that in the past tense, in Charleston, West Virginia for more than 40 years. 3 years as a solo practitioner in a small firm, and 30 years with several of West Virginia's most distinguished law firms, and now again as a solo practitioner. He is a mediator. He's a member of the dispute neutrals, the National Academy of Distinguished Neutrals, the NADN. Always have to get my alphabet soup correct there. He attended Washington and Lee University, graduated from West Virginia University with his BA, and also from West Virginia University College of Law with his JD. He has been practicing law in West Virginia since 1981. He's taken over 100 jury trials to verdict in state and federal circuit courts, district courts, circuit courts, and he's tried a wide variety of types of cases. He is a fellow of the American College of Trial Lawyers and a member of the FDCC. He's been included in Best Lawyers of America and Super Lawyers. He actually also has served as a leader in the bar. He was the president of the West Virginia State Bar from 1998 to 1999, and as his bio says, he was the first lawyer of color to hold that position. And he has served in so many positions. We're just thrilled to have you here today, and we look forward to what you will be teaching us, Elliot and Brenda. And your food banks are our Covenant House and Fish of Clark County. So at this point, the floor is yours. If you could tell us something about your food banks briefly, and Natalie will put the links in the chat, and then tell us all about those first 5 minutes. We'd really appreciate it. Thank you.
The food bank that I selected is Fish of Clark County. I live in a county that only has about 15,000 people in the county, and the town I live in has about 5,000 people. And Fish is kind of a bit of the glue that holds the whole county together. Everybody in the county participates, Boy Scouts, school groups, church groups, everybody participates, and their distribution is so incredible. They just put it out in the backyard and tell anybody who's hungry to come and get it. So it's a really great organization, and I'm very pleased to be able to speak on their behalf today.
Yeah, and Covenant House has been in the Charleston, West Virginia area for a number of years now, and has really helped us deal with the issues that we have with that everybody has, with so many people who are without a home or without enough food. And we're really proud of that. That Covenant House has weathered a lot of political storms that are now very visible, where city officials wonder whether it's a good thing to invite people from other places to come and become nourished. They have been on the forefront of that, and they've done this in a way that has been very good, and we're just proud to see that they've survived for well over 40 years themselves. So that's my food bank that I suggest donations to. I know that the links to those food banks are in the chat. So with that, Brenda, do you want to go ahead?
Okay, let's start by sharing the screen. And I'm going to click the little box that says share sound, which is great because I don't always remember to do that. And I'll share there. We were just discussing before we got started, wondering what the trick would be, the complication might be. So loading the slideshow is a little bit of maybe that's the only complication I'll have all day. So that's good.
I don't know. One of the city service trucks is pulled up outside of my office and with a big pipe on it. So I don't know what's going to happen. So it's going to be quite an adventure.
This is just, I think we've already had adequate introduction, but those are the slides that we usually have at the beginning of our presentation because we don't always have someone to introduce us. So thank you, Jean, for that introduction and for saving us from having to outline some of that ourselves. I would like to point out for you guys before we get started that I do have a short paper that'll kind of consolidate a lot of what we're going to talk about, called The First 5 Minutes, and some sample forms. I put them up on my website. They'll probably be there for a week or two. Just go to the website, that link that you've got there, you should be able to download it. It's not any great work of art, but it kind of summarizes some of the resources that we'll be sharing today. And it might help you if you have a hard time following some of what we're talking about. One of the things we're going to be doing today, we're going to be as interactive as we can. And Elliot and I look at our presentations, not so much as us teaching anybody anything, but all of us learn together. We raise an issue and then we talk about what we might do about that issue. And so this particular presentation came about when I was working a couple of years ago with some mediators in Pennsylvania. We were talking about the structure of mediation and what does mediation look like from the point of the participant of the mediation, or especially, if it's a litigant. And so it's a little bit campy video will help to maybe start making us think about what is it like if you're in litigation and you end up in mediation. So it's just about a minute long. We'll look at that, and then we're going to talk a little bit more about having a client-centered viewpoint about mediation, and especially those first 5 minutes. So that's the way I was kind of trained to do mediation. I think a lot of us were trained that way. And so we've been trying to explore, is there a better way? Is there a way that we can construct our mediations so that the participants are centered and that the stakeholders are the ones that are talking and being heard? And so we've kind of boiled that down into a couple of different parts. One is preparation, and the second is listening. And so we're going to start today talking a little bit about how preparation to mediation can make it so when the mediation begins, the litigants or the participants can be front and center. And then we'll go on and talk a little bit about different ways to listen and structure that first 5 minutes to be able to avoid positioning and to really be able to put the participants at the center of the mediation. So, Elliot, I think you're going to
Oh, sure. Yeah. I mean, our thesis is that there's a way to get better satisfaction out of the experience that we give to litigants during mediation. We think that we can, that if we invite them in and make them a centerpiece of the mediation, you would think that would be something everybody would know, that we are going to make them the centerpiece of the mediation, but that's not the way it always works. And Brenda's slideshow lets you see that. Often there are lots of different ways that lawyers have to approach their clients' participation in mediation. We designed this program during COVID, of course, and we saw that, so we tried to find some kind of way to get people to have an interactive presentation about all of this. And what I did was I videotaped a number of lawyers making telling us what they think about the level of participation their clients should have in the mediation. That ranged from, I want my client to talk, I want my client to express him or herself, to the role is not much, as one lawyer quoted. We don't have to put that on today because this is a bit of an abbreviated presentation, but it's kind of surprising to us how many different ways lawyers have of dealing with that, and how many different ways they advise their clients of that. We believe that preparation and listening are the biggest things that we need to do to make sure that the litigant experience or the party experience during mediation is at the forefront. One of the things we talked about too, and one of the things we think might help to get all of that other stuff out of the way so that the party can really be the centerpiece, is having pre-mediation conferences, is what we've discussed. But there are a lot of ways to do that. Some people have pre-mediation conferences with just the with just the lawyers. Some have them with the parties. Some have them separately, where you talk to one party and then talk to another. And there are a lot of ways to do that, and all of them can be very effective. So what we want to do, as Brenda said, we look at ourselves as facilitators of a meaty discussion more than as teachers to try to teach you all what to do, because there's a lot of experience on this call. I see we have about 87 people on this call, so there's a lot of experience here. We don't have the answer, but we hope that we can inspire all of us to find our answers in this. So the first thing we want to talk about is pre-mediation conference and the role that can have in letting people, in putting the litigant or the party at the forefront. What I want to know is I want to ask you a couple of questions, and what we're going to do is type some things into the chat box so that you can respond to some of these questions. And Brenda is going to, we'll just go back and forth. Brenda will kind of report out some of the responses that are more outstanding, or for some of the responses that are more common, so that we can try to talk about those. The first thing I want to ask is, who uses a pre-mediation conference? Type something into the chat box and let us know if you use a pre-mediation conference. One other thing we might want to do is, I don't know whether we have the gallery so that we can see everybody, but what do we have? Let's hear from somebody who uses a pre-mediation conference. Do you see anything interesting there, Brenda?
I need some help from somebody. I am not sure. This is the first time we've used this process, and I'm not, when I'm clicking the chat, it's not showing me the chat box. Can somebody give me a tutorial on how I can be able to see the chat? Can I do that when I'm sharing the screen?
Yes, you should be able to. Down at the bottom, there should be a thing called chat. And if you don't see that, maybe it's linked with something else, like, more or something, and you go to that.
Yeah. I guess I've been able to see it somehow, and I can.
I've never had this happen. It's not showing up.
Well, naturally, when we're here, this is the way it will happen. Let me go ahead and we'll work on that, and I'll just talk to a few of you because I see.
Anybody that's got their, and it's kind of funny. Elliot and I had a discussion about whether to use this method, and he said, "Can't we just do it as a conversation?" And I was like, "I really want to try this chat thing where I read it back." And it looks like that's not working. So yeah, Elliot, looks like we got some hands up. So if somebody's got some answers to the question about whether they use a pre-mediation meeting, or who doesn't, and like hear from them while I'm trying to figure out how to sort out my problem with the chat, that would be great.
Yeah, good. I don't know. I do see. Let's see, Lisa Curcio. I know you said you always require conferences. Lisa, can you talk to us? Can you unmute for a second and tell us about that? I know you didn't expect this, did you?
No, I didn't.
Okay, we'll make you a star, right?
So
Lisa, you always require them. Why?
most of my cases are in construction disputes, and they tend to be complicated. I often have multiple parties, multiple issues. I will say that most of my conferences, at least the initial conference, only involve the lawyers. But depending on the case, I will then do individual conferences with different parties and involve the party representatives if it looks like it will be useful in advancing the process.
Right, right. And I agree with that. Jeff Kachavan, you said that you use pre-mediation conferences all the time as well. Can you unmute and tell us about that?
Sure, Elliot. Happy to. Thanks for asking.
Sure.
The most important thing is that there's always more to the story than what you get in the written briefs. There's personality issues. There's things about lawyers' relationships with their own clients. There are things that lawyers are either not very accustomed to putting in writing or not very comfortable putting in writing about these interpersonal issues. And oftentimes those are the most important things in terms of actually getting a case settled. So you have to know about those things in order to deal with them effectively. And I find the oral communication is better than written communication for finding out what's going on below the surface.
Thanks, Jeff. I know we lawyers are notoriously averse to putting a lot of things on paper that can come back to haunt us or something. And for that matter, some of these things just don't need to be on paper and don't need to have it seen by stray eyes somewhere. And so I always, the way I phrase it is that I want to know if there's more than meets the eye. And more than meets the eye indeed means that you have some. There are some things that they don't feel like saying either in front of their client. There are some things that they don't want to say to the other side. And there's some things, even if the other side was in the room, that they don't necessarily want to say that way. And so that's the way I use a pre-mediation conference. My practice is primarily civil case litigation. And I have now opened up to family law mediations, but I was a little scared to do that. I said that when I did divorces back when I first started practicing, I think that delayed my getting married, and I'm sure it would. As a matter of fact, for that marriage, it probably should have delayed it a little longer. But let's talk about some of those of you who don't use pre-mediation conferences. I've got mine on gallery, so I can kind of see some of you, and so let's talk about some of the people who don't, because I did see some folks who said that they don't like to do that. So let me see some hands from somebody who might say that they don't use pre-mediation conferences, or maybe, you know, you type that in the chat. I can see the chat. So let me hear
Yeah,
from somebody.
I've got this. The chat doesn't work whenever I've got the slideshow on, apparently, for whatever reason.
Oh, okay.
And I
All
did
right.
see
Well,
that
at least
in the
works for
chat,
me.
it looks like a lot of folks here do usually use a pre-mediation meeting. Somebody said that they do it because they want to make sure that there's safety issues addressed. Somebody else says that it helps to reduce anxiety. Others indicated that it helps to be able to get better informed about the issues. It looks like some maybe just talk to the attorneys. Some are considering it. So it looks like, though, there are quite a few people that have some type of pre-mediation contact, either with attorneys or with the parties. So those of you who have anybody want to answer the second question in the chat box or raise your hand, like who doesn't use a pre-mediation conference and why do you not use one?
Mhm.
We
Yeah,
got,
if somebody deliberately does not, I'd love to hear about that.
it looks like Nancy Harrison, you have your hand up.
Mhm. Yeah. Let's see. There, Nancy. I see you there. Nancy, could you unmute and talk to us? I see. Hmm?
Yeah, I've unmuted. Is it not here? You're
Oh.
not hearing me?
We can hear you.
Yeah, Nancy, we can hear you. Go ahead,
Okay.
please.
My practice is primarily referred, and pretty much for the most part, it's all workers' compensation cases, which was my area of practice. So most of the time, I know the lawyers, and we're mediating typically fairly narrow issues. Sometimes one of the lawyers will alert me that, you know, they've got a particular client problem or something like that. But I guess I'm sort of, I have a further question that I put in there. It's like, if you're talking to the people, why are you calling it pre-mediation and not part of the mediation process? I mean, you know, when I start the mediation, I introduced yesterday, I was thinking like, I'm kind of talking a long time, which is partly a function of doing things by Zoom. But and sometimes people, they want their client to be involved or they don't want their client to be involved, depending on the client. And I know most of the people I'm meeting with, you know, some a yak, or you know, or the lawyer does the whole thing just because that's the way the client, they want to handle it. And the same lawyer can do it differently depending on their client. But I guess I don't understand why you're calling it a pre-mediation. Like, it's part of it is part of the whole process. And I guess with the court referred ones, you know, we're paid for 2 hours of mediation. That's what we get paid for. So I think in the court ordered ones, and particularly the people I know who do work compensation, were not included.
Okay. Now, Nancy, we're not hearing some of the things you're saying. We're not hearing some of the things you're saying just because of the connection. Let me talk to.
Sorry.
That's all right. That's all right. Let's talk to. There are a couple of other folks who had some things. Janice Ty, will you unmute? Yeah, Janice, what?
Yes. Hello. Good morning. Yeah. Good morning. In one of the areas that I work, we do not do pre-meets. It's in a court jurisdiction. The litigants are sent to mediation, and it's not a litigation process. So interestingly, we do not start with the lawyers presenting positions. Lawyers have already had that opportunity through the claim and dispute notes. So part of the beginning of the mediation is clarifying roles, including the roles of lawyers or counsel. Participants represent themselves. So we start with the participant's story after they have agreed to the process. So in that situation, we are really focused on effectiveness for time. And so that's the reason that the court does not include a pre-meet in that situation. Now, in other situations, yes, I agree with all of the comments and so forth, that yes, we use.
And speaking
like
of
this
time,
is happening based upon what
Elliot,
kind of,
Elliot, we're running a little bit short on time. I think that we need to go through the next two slides pretty quickly. And I think that some of the questions you guys have raised, we're going to raise a little bit later in the program, particularly about how to elicit the storytelling and a little bit more about why we're calling it a pre-mediation meeting. And so we're going to have to go through these next two slides quickly. So if you can just type in the chat box, you know, is your pre-mediation contact with the parties? Is your pre-mediation contact with attorneys? Just type in the chat box and share that way. If you don't mind, that'll make it so we can move through a little quickly. Is it by phone, video, or in person? Do you get written materials before the mediation? And is there anything else that you want to add about your pre-mediation contact? So just if you could type those things in the chat box, and then we'll look to also to hear from those of you who don't. Elliot, you want to?
Yeah, sure. I haven't, you know, I didn't say anything, of course, but Brenda is my police officer on time, and sometimes I get a little loose on this, and so that's why the synergy is so good that we find a lot of ways to complement each other, and this is certainly it. When we talk about pre-mediation contacts, you know, let's talk about that. The question that you raised just a while ago about pre-mediation. You know, what I use, the words I use are the mediation session, and I talk about about the session as opposed to the part of the mediation that I'm doing before we get together or get in the same building together. And so you know, it is, I think that's a language thing that does need to be corrected so that we can correct that in our own minds. Let's see, I see a couple of things in the chat. You say Kristen Rickon says that she never does the pre-mediations by phone or pre-session contacts by phone, but does that in a brief. And you know, as we said, there are some things that people, you know, don't necessarily want to say, and I'd love to hear or love to discuss how we get past some of that. You know, whether they include the parties to the mediation. You know, one of the things that Jeff was saying is talking about some of those things that are more than meets the eye. And I see from insurance adjusters, people that lawyers that are working with insurance adjusters sometimes don't want to betray a lack of confidence in the case that somebody may think looks like they're afraid to try. And so that becomes a bit of an opportunity where we can use the pre-session conference to let them say those things that they otherwise wouldn't be able to say. You know, the question about whether the parties are involved. Brenda, I know you do pre-session conferences where the parties are involved. Talk about that.
Yeah, it really depends on the type of the case, what I do, but I prefer to meet with the parties ahead of time. Sometimes it's jointly with all the parties, sometimes it's individually, and addressing the question about what is it part of the mediation. And I feel like when I'm talking to the folks themselves and I say, the mediation is going to be on Monday, but the week before that, we're going to meet and talk about it. I think that helps them to know that on Monday, they're going to get to tell their story. And when we get together on Wednesday before that, they're going to get to hear about what the setting is going to look like. So it is kind of all comprehensively part of a mediation, but I really like the parties to know that when they come in for their mediation, they're going to be heard. So yeah, Elliot, sometimes I work with parties, sometimes just attorneys, and it just depends on the case. But let's go ahead and look at the folks that are not using them and what the challenges are, so we can talk a little bit more concretely about those first 5 minutes and the storytelling that somebody mentioned earlier that happens in that first 5 minutes. So if anybody can think of challenges to having a pre-mediation conference, please feel free to type that in the chat box, or a way that you might address the challenge that somebody else is typing in a chat box. If you can think of a challenge or a way you might address that challenge.
Yeah.
And then if you're not having them and you think you're comfortable not having them, I mean, what can you teach us about why we shouldn't have a pre-mediation meeting, or what to be worried about a pre-mediation meeting, or where the caution is there on the pre-mediation meeting?
Yeah, do we have anybody who's weighing in on that? You know, one of the things we talk about is the difficulty is some people don't want to assemble their client for a pre-session conference. You know, we don't, and others, as I say, may want to say something they don't want their clients to necessarily be involved in. But for the you know, you see, I'll go with the cons first. We talk about logistics, and I think Brenda typed this in, especially before video options. I mean, right now we have video options where we can let the party see us and develop some comfort with us before they come into the mediation session. Some people don't want to spend that much time, and there's some kinds of cases that we handle that don't have that really, you know, don't get that kind of time. I heard you talk earlier, I think it was Amy, about you get 2 hours and that's it. And so the question is, why do you spend some of that time on something that happens before the session or not? Any other talk about why not to? You know, Brenda, what are you seeing in there? What are you seeing?
I actually,
I like that, you know, Don Rose says that he usually has a Zoom with the attorneys before the submissions. That's an interesting way to do it. I know I always wait until I get the submission, so I'll be able to have a deeper talk with the person who's who's submitting that to me.
I think that we had a lot of pros to add from the chat that happened initially, and I appreciate everybody that. Now we have some more additions to make on this slide. When we look at the pre-mediation conference, here are some of the content that you might have at a pre-mediation conference. And again, what this does is help set everybody up to come into the mediation ready to participate. And it depends on what kind of case it is and who's involved as to what you're going to do. But I usually like to make sure the agreement to mediate's signed before we even meet for the mediation. And that's probably the most important thing that happens for me in the pre-mediation meeting with the parties, is to sign the agreement to mediate and make sure the parties all understand what mediation is. So many times they come in and they have no idea why they're there or what's going to do, and they think I'm actually going to make a decision. So these are some of the things that you could have at a pre-mediation conference. And if you want to type into the chat box, if you can think of anything else that you think is important to include in a pre-mediation meeting or conference, that I'm sure everybody would love to hear that. The other part is the logistics and how you set it up. You know, I typically have I have a person that does a lot of my client relations, and that's the person that does a lot of the setting up the pre-mediation meeting. We use online scheduling, and just the real key is to make sure that they understand that this is a meeting to get ready for the mediation. And so the logistics usually involve the online scheduler and my client relations person. So having covered the pre-mediation meeting, that's the preparation we were talking about. We are going to change gears a little bit and look at listening.
When we talk about people, about how the parties get satisfaction in a mediation, parties want to be heard. I have a friend who has used me for mediations, but really doesn't like to use me because he likes to kind of beat up the mediator a little bit. And he doesn't want to do that with me because we've been friends for quite some time. So, you know, and one of the things he said, he has a different way of approaching mediation. He, you know, perceives himself as a high-dollar lawyer who guides his client through the case more than, you know, there's not a whole lot of self-help when he takes over a case. And so he wants to be the one who does a lot of the talking and that kind of thing. And one of the things he said to me that I put in, I made a blog post out of it. He said I was too slow on the wind up. Too slow on the wind up. Because what I wanted to do was to hear what the client had to say. And I wanted to give them time to talk and to become familiar with me and to feel and to develop confidence in the things that I would say to them when I come back from the other room. So I do give them time to do that. I do try to ask them, how are they doing? I mean, completely aside from the lawsuit, how are you doing? How are you feeling? How are you, you know, how is your life right now? You know, somebody who's very heavily invested in the lawsuit is going to start to talk about their aches and pains and things like that. But sometimes you get a real revelation when you see this person that says, look, I'm making it. I'm doing okay. I'm doing what I'm supposed to do. And I'm just trying to survive, but I do need compensation for whatever happened. That slow on the wind-up thing, I thought was kind of funny, because I think it belies a lack of understanding about how to get client satisfaction out of the mediation. Brenda, you and I have talked almost, I guess most of the time we talk about how to try to make this a valuable experience, because it has to substitute for being in court. You don't get to go to court a whole lot anymore. And so how do you make that experience feel like they got their day to say what this other party, what they believe this other party did to them? You know, the way we do that is by giving them a chance to talk, and by us listening. You know, we think that's awfully important. There's several ways to listen too, and Brenda's going to talk about some of those and from some of her training.
So I learned a lot when I got my master's at EMU. I went to the Center for Justice and Peace and got a master's degree. And that was the first time I heard about appreciative inquiry and narrative theory of conflict. And after I did that, I was doing some court referred mediation in Berkeley County, and found that we would sit down for the mediation and I'd ask everybody, how they felt or what was going on or to tell their story. And what I noticed is that they tended to get very positional with that type of a question. And so I reached into my reserve of knowledge that I had gotten from EMU and thought, wait a minute, how can I begin this conversation with the parties to the mediation without them immediately getting positional? How can I put that on hold long enough for me to be able to try to figure out that underlying interests and see if we can meet those? How can I figure out whether there are issues of identity that are going to have to be addressed within that mediation? I mean, what can I do to stop this from looking like an adversarial proceeding where one person tells their story, then the other person tells their story, and that the mediator then tries to figure out how to make some type of a common ground there? Is there another way not to get positional and to have the stories come out in a different fashion where we can start by looking at shared interests rather than try to dig those out after the parties have already started going up and down that well-driven path of their positions? So I've come up with 3 ideas on how you can begin a mediation with listening that doesn't ask for positions and doesn't nail people into their positions. And so I'm going to talk briefly about each of those. And I'm certainly not an expert on any of them, but I have found them to be pretty helpful. So many of you may have heard of appreciative inquiry. David Cooperrider came up with it when he was working with businesses on how to improve their business. I think his first contract with this was with Hunter Douglas, the blind company. And what he says is that if we focus on what is working and build out from there rather than what's failing and focus on that, then we'll have better opportunities for growth. I think the same thing happens in mediation. How can, instead of starting by where's our conflict and what's wrong, how can we start by looking at what the potential common ground is and build from there? And an example.
May I jump in to say something? Brenda?
Sure.
I want to compliment you, because you know, in our work together, we not only just talk about these things for the purpose of presentation, we talk about them so we can learn too. And I had an incident where a local university had some conflict between its administrators. And I hadn't really heard of appreciative inquiry, and our talks, the talks that Brenda and I had, really clued me in and really helped when I met with these administrators to start to talk about the good things, and got them in a different in a mood to talk about their conflicts in a very, very different way. So that's one of the things that appreciative inquiry does. Brenda, you have another example. I'm sorry to interrupt, but I just thought it was important.
No, I'm glad you did, because that shows another context of where you can use it. And it's not just for a family law case, but that's where I find it to be really helpful. So that when I'm working on meeting a parenting plan, instead of starting and saying, well, who wants what, or who wants to change this custodial time, I start with saying, well, what really works for you about this plan? Or what makes your child thrive? Or what makes you feel good as a family? I mean, start with what's really working with what you do. And every now and then, of course, I get somebody that says, nothing works, this whole thing sucks. But most of the time, if I'm patient and try to focus, really keep asking questions like, well, when is the last time you had a really great time with your child? We can get to that appreciative inquiry part and then build on that and say, okay, well, here's where we've got what you guys really like. How do we build on that to make your parenting plan work? And again, you've got the materials that you can get the article, and there's a little more detail in that. So conscious curiosity is in some ways, it's so simple that it's odd that I would include it. But basically, it's an idea of suspending your judgment. And of course, as mediators, that's what we're trained to do. But as lawyers, we often rush to judgment. So I find by thinking about conscious curiosity and trying to, when I begin the mediation, rather than trying to discover positions, just start asking questions that I'm curious about and that I have genuine curiosity about, to get the folks talking and sharing that information to me. Again, I find it challenging to suspend judgment and not think about the legal case during this stage, but I find that conscious curiosity can be a good way to elicit the information and learn more about the problem before you start looking at positions or solutions. And in the area that I found that to be particularly helpful is in elder mediation. If I'm working with a family that's trying to figure out, where mom and dad should be living, instead of saying, well, sister, you want her to go live with you, and brother, you want her to go to the assisted living home, we can start talking. It's a lot like appreciative inquiry, but instead of looking for what's succeeding, we're looking for what the questions are. What do they need? How do they get that? What makes them happy? So, this is very similar, but it's it reminds us to ask questions and listen rather than talk, and consider holding back on positions until we get more information. The third type of a tool that I think is helpful in mediation is to think about narrative theory of conflict and bridging narrative. And we have to remember that the stories are kind of a reality for the participants in a mediation. And so we have to kind of uncover that reality and figure out what the stories are and elicit enough information to develop full coherent stories, and then start finding the parts of convergence. I was thinking about this yesterday, Elliot, after we talked, that in some ways, this reminds me of when I was a prosecutor and I would do a cross-examination. I would look for the common places of the story and have the other party agree. And so as a mediator, you're doing the same thing, except for the purpose of that isn't then to try to push this through the adversarial process, but rather to find those points of convergence and see if you can create a bridge of the two narratives. I find that this is helpful in an automobile accident case. Often the parties agree to a lot of the facts around a case. Sometimes they don't. A lot of times it's just about the types of injuries. And so finding out what both parties experienced in that accident and figuring out how those narratives can coexist or kind of survive independently without one of them kind of becoming the master narrative over the other one is one way to try to approach that automobile accident mediation without getting positional. What are those points of convergence? What is the shared narrative, and how can those two people's idea of reality continue to exist without one of them feeling like that has been attacked? And so
that's really important because the favorite tactic of people in litigation is to say, well, if so-and-so said something else, is he lying? And instead, what Brenda's talking about is bringing them together on the common parts of the story instead of trying to highlight the gap in the stories. And it takes away a lot of that hostility. Go ahead.
And so again, back into the chat box, or we can also just probably discuss. I think we have enough time to be able to discuss this a little bit. So I guess I'd throw this out there to all of you. What do you guys see as the purpose of that first 5 minutes of the mediation session? You can raise your hand or type it in the chat box, or both. Anybody? What's the purpose of the first 5 minutes? How would you characterize that purpose?
Yeah, we'll talk about those in just a moment.
Type it in the chat box, and also, so Kate and David, you have your hands up to.
Mm-hmm. Yeah, good.
Yes, although I could put it in the chat box. I'm seeing the chat box now. I think one of the most important things is to get the people comfortable while being clear about our neutrality. That often settles people down quite a bit. And I don't think of my pre-calls as, I don't think of what I do as being a pre-mediation call, but it really is, because I clear up the issue of, are there going to be other parties involved? I don't get into too much on documents, because that is going to make that call 45 minutes longer, and I'm not charging them for that. But to basically tell them, you know, I don't make decisions and all of that. So in the first 5 minutes, we already do have some degree of an association, some degree of a relationship.
Mhm.
So,
David, there's David Geffen there who has had his hand up. He was going to make a comment on the other part we were talking about. David, can you unmute so that we can, let's see. Yes, because I'd love to hear your comments. Let's see, David, did you just get your, I don't know, did that just get stuck there? Okay. All right, we'll move on. I'm sorry. It's just that he had his hand up before.
There we
I
are.
wanted-
I'm right there.
Oh, there he is. Oh, well, ladies and gentlemen. Yeah, David, go ahead. You were going to have a comment.
Well, thanks for that. I just wanted to say about this particular portion, the first 5 minutes, I want everyone to know what they can expect of me and how I will give everybody an opportunity to say what they want and take the time they need to say it. And also just to let them know my personal style so that they relax. I know so many people come to mediations very uptight, not knowing what to expect and prepared for a fight. And I calm them down and say this is a slow game, not a fast game.
That's very, very important. I mean, and that's awfully important to say it from the mediator's perspective. As I say, my friend who said I was too slow on the wind up, I guess he thought he had done enough. But the thing is that message has to come from a couple of different people within the event. And I'm certainly one of those people. So that's why I want to talk to them and, as to say, get them acquainted with what's going to happen from my perspective and help them to ask them questions they may not even be comfortable asking with their own lawyer. So these things happen. So
I do find by the cases when I don't do a pre-mediation, for some reason, I did one last week where I didn't have a chance to do the pre-mediation meeting. I wanted to get right into their mediation. And I do find that they are so much more defensive and less trusting of me when they show up for mediation and we haven't had that half an hour conversation beforehand. And yeah, they just come in with a different frame of mind. And they just seem like they're less prepared to be able to talk with one another. I feel like whenever I haven't done a pre-mediation meeting, I have to use a lot more caucus to be able to move forward, that the parties are less able to communicate as well as they can when they've had that chance to learn more about the process and sit with it for a few days before they actually attend the mediation.
Mm-hmm, mm-hmm. Can we get to Mauricio's question? I see he has his hand up there. Yeah, Mauricio,
Yes.
Yeah.
Thank you.
Sure.
The words that have been said, like relax, trust, comfort, that is very important in the 5 minutes, the first 5 minutes. What I think it is very important based on my experience, and my experience is on international cases, is in commercial cases, actually. It is to tell the parties what the role of the mediator is not, because we don't know, even if we have pre-mediation sessions, etc. So sometimes what the parties want, consciously or unconsciously, they want this third party to advocate his or her case in front of the other party. Mm-hmm. So it is, to me, it is a sort of a clarification that sets up or paves the road for a good caucus, or even a good plenary sessions later on, so that you can inform what the role of the mediator is not. Also, what I do say as well, especially in the plenary session or the joint session, I say, well, here silence means I don't agree, because we don't know exactly the reactions. We don't know what people are bringing to the table, even if we had pre-mediation before. So they don't have to jump on the table and say, well, I don't agree because blah, 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 etc. So that's the kind of method that I normally use in order to calm them down.
Yeah, that's a wonderful use of it too. That's just great. We're also, the other question we're asking is, what can we do to make the clients most comfortable in those first 5 minutes? I think that's one progression beyond, Brenda, is that right? Yeah. and just trying to figure out what can we do to make them comfortable, and perhaps listening to them and letting them tell their story and get that out is probably one of the best things we can do to make them feel comfortable with the process and comfortable with the parties involved. Unfortunately, joint sessions have died here like they have in many of your practices. Sometimes I think it's good to have them, and I still get people together so they can at least show some humanity to each other. But that's pretty important too, to see the people that have been demonized on the other side for so long are really human, and that's something that I think is kind of important as well. Brenda, you want to get to the other part of what we're going to talk about in this here? Oh.
This is it. So I guess it looks like Valerie has her hand up.
Yeah.
Valerie, do you have something?
Yeah, thank you. I appreciate it. Unlike most of you that are attorneys, I'm simply a mediator. My way of doing it and the way I was taught was I talk to the clients ahead of time on the phone individually. That gives them a really good sense of trust, and they've really told a lot of their story at that point. And then, I kind of put the attorneys kind of more on the back seat. I speak to them, of course, as well. And, but they're more cut and dry. It's, I kind of get their positions. And then when we get to the mediation, prior to the mediation, all paperwork has been already exchanged via email. They've already been told exactly how the process is going to go. So that prepares them and they know what to expect. But I always bring food to the mediation, and we start out with that. And I was taught, we break bread because people are nervous. People are, some people have a nervous eating habit, or keeps them from going to, grabbing coffee every 5 minutes or whatever, or needing to take breaks, just to kind of, make this feel not so much like business. Because when you get everybody around a table, and especially I found with attorneys involved, and the more caucusing you do, you take that human factor away. If we're at the table and we're looking into each other's eyes and we're hearing the voices and we're seeing and feeling the feelings, I think is really super important. And that's how I approach things.
Mm-hmm. Mm-hmm. Yeah, I think that's great. I've heard some people talk about bringing food to mediations. Some of them talk about that as a marketing tool, but I think that the way you're using it is really a great way to use it, and that is it creates an atmosphere that's a little more like home, an atmosphere that's much more relaxed. And that's something that I never would have seen in a seminar about what we can do to make clients more comfortable with the early part of a mediation.
And Kate, you have a comment or question? Or no?
Yeah, Kate, I didn't know whether Kate Reese, I didn't know whether that is whether you simply wanted to put your hand down or what, or hadn't put it down yet or something.
Sorry, I clicked it, but it didn't take. So there you have it.
Okay, great.
So here is our contact information. If you guys would like to get back in touch with us to discuss any of this, or if you have any questions, there's our contact information. And the picture there is a fall hike in Lewisburg, West Virginia, which is probably about halfway between where Elliot and I live, along the Greenbrier River. It's a really beautiful part of the country. I'm going to stop sharing my screen and ask everybody, after this presentation, you can either type in the chat box or go ahead and raise your hand. I mean, is there anything that you think you're going to be more aware of going forward in the first 5 minutes of your mediations? Is there anything that somebody said today or that you thought about that's like, I'm going to start really paying a little bit more attention to this, or I might change this? Anybody have any feedback on that?
This is Jean. I liked one of the comments in the chat said that he told the people that if they write down their question, he will give them, he or she, I'm sorry, whoever it was that wrote that, think it was the gentleman, that they will give the person the time to talk uninterruptedly if they, the mediator can finish what they're saying, which sends a message about listening.
Jim Matulis asked a question about, or made a comment about the pre-mediation or pre-session meeting and how you have one without looking like you're just trying to beat in some more billing time. I think the quality of that time is what makes that happen. If there are important things that are discussed and described there, if there's important information that advances the ball a little bit, I haven't heard anybody complain about that. Now, certainly there are sometimes when a lawyer will kind of be a little, I already put in my statement, there it is. And they'll kind of send a signal to me that they don't necessarily want to probe further. But, and that's fine. We have to be cognizant of the cues that we hear from others too. So I think they'll kind of tell me, but I haven't heard anybody complain about that. I haven't heard anybody say, wow, that was pretty useless, because sometimes that's more useful than some of the things that happen during the session. So I don't know. I think that's a good question though, because I've heard people talk about that before, and I've heard, some concerns, but fortunately not very many.
I see a few things in the chat box that I would like to just talk about for a second. Looks like Paul Sheridan asked about, on the other, it's nice to have a pre-mediation meeting, but and discuss the preliminaries, but what about not giving the exact same presentation to each party, so that if you're in a joint session, you tell the parties what mediation is going to involve. It's different than when you do it in a pre-mediation session. And I think that is probably a little bit of a drawback to the pre-mediation session, that the parties don't know for sure that you're telling each other the same thing. And I just think that when I'm working on that, what I have to do is really focus on building that trust and try to overcome that concern through building trust. And Valerie asked about using elders in mediations. I try to use all the stakeholders as often as possible. Anybody else have other comments? Lori, good, focusing on what's working rather than the negative. That's great. Focusing on points of agreement. Advantages of being an active listener. It's so funny that when we do mediation training, we have all of that listening. We learn all that. We do all those listening exercises and learn how to be a good listener. But then sometimes I've just been in mediations, and for some reason, it seems like I'm the one doing all the talking. And so I think we need to make sure we're always mindful of that active listening and making sure we're using those skills. Well, we have a couple minutes left. Does anybody have any further comments about what they think about these first 5 minutes or about mediation preparation?
Well, I think I learned a lot from the notion of using appreciative inquiry. I'm familiar with appreciative inquiry, but I had not thought about using it in the sense of a mediation, and how to, as several people in the chat comment, how to focus on the positive stuff. So appreciative inquiry, that to me is a good learning outcome from this session. I appreciate that. Thank you.
Thank you.
Right. All right.
Well, it's 1 minute till the top of the hour. Thank you so much. It's been fascinating, Brenda and Elliot. Thank you for being with us today. Thank you, everyone here. We had more than 80 people at the height. It's just great. Jeff, do you have any comment or thought that you wanted to express before we say goodbye?
Just want to thank everybody for being here and hope that they are able to contribute. If they are able to contribute, please consider the Covenant House of West Virginia and the Fish of Clark County food banks. We appreciate that. Thank you all.
And if you would let us know, we would be thrilled to add it to our running total of